Hello and welcome to the legal section of today's Toolbox talk. My name is Sarah Pengelly and I am a Senior Associate with McRoberts. We are a full-service firm of solicitors with offices in Edinburgh, Glasgow and Dundee. I am part of the construction team on the non-contentious side, which means I draft, advise on and negotiate building contracts, consultants' appointments, collateral warranties and a raft of ancillary documents for a wide range of projects from domestic, residential and commercial buildings and refurbishments to hospitals and schools, as well as roads, railways, wind farms and biomass projects. Today we are looking at reducing exposure to non-payment and giving you some tips on recovering bad debts. Let's start with a few facts. UK construction firms are writing off an average of £10,000 each year because customers do not pay. More than 70% of SMEs in the UK construction sector suffer from bad debts, nearly £2 billion overall per year. In 2012, only 5% of work done by small construction companies was paid for on time. However big your business, cash flow is critical to its survival and success. Cash is king. You shouldn't be so focused on the day-to-day challenges of running your business that cash flow management is overlooked. Today we will discuss various ways of protecting your cash flow and therefore your business. In relation to payment, there are 3 stages at which steps can be taken to try to protect your position: pre-contract, during the contract, and once a debt is overdue and formal action is required. We are going to look at each of these in more detail. At pre-contract stage, the decision is whether or not to do business with the contractor or person offering work. When business is hard to come by, the temptation is to bash on and take the risk, but it makes sense to take some steps to understand what the risk is before getting started. Prevention is often better than cure. Where your employer is a company, take up trade references. What is the company's reputation in the market? Do you know anyone else who has worked for them? Choose your own referees. Those provided by the company may have been carefully selected to be friendly. Look on Companies House. Certain checks can be done free of charge on the website, others have a small charge. Check if the company is up to date in filing its accounts or annual return. Look at the filing history. Have there been any applications to strike off the company? Check the mortgage index to see how many securities it has granted and over what assets. The annual accounts generally show a historic position, but will give some indicators about the financial position. Look in the Edinburgh Gazette. This publishes all public notices relating to corporate and personal insolvency in Scotland, for example, applications to appoint a liquidator, and it is useful for domestic employers as well as commercial entities. It's available online and is free of charge. This could be useful where you are contracting with a private individual. Obtain a credit report. There are a number of websites, for example CreditSafe and Company Watch, where you can obtain a credit report. It includes an overall credit score, and CreditSafe uses a traffic light system. Some also have a monitoring service with emails alerts for any changes. And do a drive-by of the employer's premises. Does it look well maintained or run down? This may give you an indication of the state of your employer's finances. Importantly, set some rules that you always follow when entering into contracts and don't be tempted to break them. When considering the terms of contract, look at the payment provisions. What payment terms apply? How many days will it be from your application until payment? Can you manage the cash flow implications of that? Retention dents cash flow, and some contracts are applying high retention percentages. We have seen up to 10%, although the more usual levels are 3 or 5%. Of course, if you are contracting with an individual, there may not be any retention. Consider whether a retention bond is an option in lieu of deduction of retention. These are not common in practice due to the cost of obtaining them, but that may change. If taking a bond, look at the provisions of when it can be released. Are you able to build the cost of a retention bond into your price? Separately, with retention, look at your debtor books. Are there outstanding retentions you could be pursuing? Remember, standard forms are usually amended so that you are effectively taking the insolvency risk of your employer. Look at the level of interest in your contract. Most standard form contracts provide for interest to be applied to late payments. Where the contract does not provide for interest, the Late Payment of Commercial Debts Interest Act applies. It provides for interest to be applied at 8% over base. It also allows a claim for a small recovery fee. Recent regulations in Scotland may allow a greater recovery of your costs. Look at the interest rate that has been set out in your contract. Is it enough to cover your finance charges? And finally, battle of the forms. This comes down to whose terms and conditions apply to the contract. If they are not yours, then you could be prejudiced, for example, by long payment periods, high retention rates, and caps or exclusions of liability. There are some steps which can be taken to alleviate cash flow issues where it is necessary to purchase materials on long order or where materials are purchased but stored off-site. In England, a vesting agreement can be entered into so that title passes to the employer. This allows payments to be made earlier than they would under the contract. In Scotland, this is not valid, but it is possible to enter into a contract for the purchase of off-site materials to achieve the same thing. In some cases, such as steelwork design or orders of steel, where there is work required early or material on long order, or where the contract is not yet finalised but is close to it, a letter of intent can be used as a short-term stopgap to allow payment to flow. This reflects commercial reality and is not a preferred legal route. In some cases, advance payments can be agreed, although this probably depends on the bargaining strength of the subcontractor. Sometimes security would be sought by way of an advance payment bond, but there would be a cost attached. Project bank accounts are so far not commonly used, but may increase in popularity. However, recent figures seem to show that the majority of public sector bodies do not plan to use them. Basically, the way they operate is that the employer pays money into the account, and as payments are certified to the contractor and subcontractors, the certified sums are paid out of the project account directly to the contractor and subcontractors. You are therefore not waiting for payment while your employer sorts out its admin issues, nor are you taking the insolvency risk of your direct employer, unless, of course, your direct employer is the one paying into the bank account. During the contract, there are a number of steps you can take to keep the cash flowing and remedies available if it is not. It is vital that you make applications for payment in accordance with the contract provisions. In subcontracts, these will usually be timed to allow the main contractor to include them in its applications. If that timing is missed, it is likely to lead to delayed payment. Make sure you comply with all the administrative requirements of the contract in terms of notices, form of applications, recipients of applications, etc. Include applications for any varied work. It is better to do this as the work progresses and not save them up until later. It will also flag any sticking points on these early. Follow the contract provisions for payment notices and default notices. With the new Construction Act provisions, if the payer does not issue notices, the payee can do so. You will of course know that the Construction Act does not apply to contracts with residential occupiers. Check the terms of any Payless notices issued. Are they on time, and do they include all the required information? If they are not valid, the sums cannot be withheld. These are a product of the Construction Act, but your contract may provide for these whether or not the Act applies. Under the Act, there is a right to suspend if payments are not made by the final date for payment. This requires at least 7 days' notice to be given in the appropriate terms. Sometimes giving the notice is enough to unlock payment. Check your contract. You may have a contractual right, albeit not a statutory right. Some standard forms include as a ground for termination not making payment by the final date for payment. Usually a notice of intention to terminate or a default notice is given first before the actual termination and, again, sometimes this can unlock payment. Use with care though, as late payment in the absence of a contract term would not normally be enough for termination. A statutory right to adjudicate under the Construction Act can be used at any time, so if disputes over payment are arising and the sums are at a level to justify it, this can be used. Again, check your contract because there may be a contractual mechanism even if the statutory right is not available to you. Sometimes, despite all of the above, it is necessary to take further steps. If it becomes clear that a party is stalling, then don't delay in escalating the issue. Often it is a case of he who shouts loudest being paid. Negotiation is often a good starting point. Discuss what the problem is. Is it a genuine issue, or is there some underlying problem, such as contractor cash flow problems? The first step we would usually take is a letter demanding payment in 7 days. That can sometimes be enough. Another option for undisputed payments, can pay, won't pay, is a blue star letter. It threatens to wind up the company if no payment is made within 2 or 3 days. Most debtors respond to these given the consequences of not doing so. A statutory demand basically does the same as a blue star letter, but on 21 days' notice. If none of the above work, or if there is a genuine dispute which cannot be resolved by negotiation, then further action may be needed. This can be by adjudication, by far the most popular route for construction cases, if you have a contractual or statutory right, or by court or arbitration. Check your contract to see if there is a stipulation as to which of court or arbitration should be used. Before starting any such process, it makes sense to look at the economics. How much is it likely to cost, and how much are you realistically going to be able to recover? Enforcement is a key aspect of debt recovery. An adjudicator's award or court decree is not worth the paper it is written on unless it can be enforced. The courts have taken a firm line with adjudication, and there are many decisions where the courts reinforce adjudication by enforcing the awards. In court, a decree is enforced by serving a charge for payment on the debtor. This is a formal demand served by sheriff officers. If the time for payment expires without payment being made, it is possible to take action, such as arrestment of funds, registering an inhibition to prevent property being sold, attachment of movable property to allow it to be sold at auction or liquidation. There is a cost to all of this, and a key consideration always is whether the debtor has an ability to pay. You can't get blood out of a stone, so sometimes it is a case of cutting your losses. Hopefully, you will be able to avoid being in a situation where you need help to recover monies due to you, but please do not hesitate to get in touch with us if you need any legal assistance with debt recovery or anything else. McRoberts is a full-service legal firm, as I mentioned earlier, so do please let us know if we can help you. Don't forget that McRoberts and Select operate a helpline offering a free half-hour call to give you advice. We have a dedicated debt recovery team who have fixed prices for the various letters discussed earlier. Please get in touch if we can help you. Thank you.